for academic purposes and does not constitute a lawyer and client relationship between the speaker and the audience. This presentation includes citations and online sources, law, and jurisprudence used by the speaker in accordance with intellectual property laws. So just a disclaimer. So our lecture outline for today. So we'll be discussing the difference first of labor standards and labor relations, then pertinent or important principles in labor law, updates on statutory benefits for 2021, and also some updates on critical issues on labor standards during this COVID-19 pandemic. Okay, so I know some of you already might know these concepts just to review for the exam. Okay. So labor standards refer to Philippine laws. Okay, I hear an echo.
Dear participant, lang po nung malakas na audio, background audio. Mr. Laher, Jomar, please. Thank you.
Okay, thank you. Okay, so let's proceed. Okay, so again, labor standards refer to Philippine laws that provide the minimum requirement. So it provides a floor, not a ceiling, regarding the work conditions, work hours, wages, benefits to be enjoyed by the worker and implemented by the management. So these standards provides a floor, meaning a minimum requirement, but it does not provide a maximum requirement. So employers and the employees are free to bargain for higher benefits, but the law mandates a floor or a minimum. The goal of labor relations is to strike the proper balance between the protection of workers.
Sir, i-unmute lang ulit kita, sir, ha? 1 second.
Okay, so thank you. So the goal of labor relations is to strike a balance between the protection of workers' rights, meaning the rights of workers as mandated by law, and the management exercise of their prerogatives, a management prerogative. So the main goal of labor relations is to foster or promote industrial peace. So industrial peace will allow the companies and the workers to be more productive, for the company to earn more profits, and for the workers to develop and earn their living. So that is labor standards versus labor relations. Okay, so let's proceed. So the main protection of labor, or the main basis for the protection of labor or our employees, will be the Constitution. So Section 3 of our Constitution provides that the state shall afford full protection to labor, both local and overseas. So these includes our overseas Filipino workers, so our OFWs.
Wala, late na siya kami.
So it shall guarantee the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concerted activity. So even the right to strike is guaranteed. However, it should be in accordance with law. It should be peaceful, and it will undergo some procedural requirements before the workers can declare a strike. And the Constitution also entitles us workers to security of tenure, meaning you cannot be arbitrarily fired by your managers, by your employer. So unlike in what we see in American movies, when we watch American movies, the manager will talk to the employee and the manager will say, "You're fired." Here in the Philippines, that is not allowed, because our laborers, employees are protected under our Constitution. Okay. So continuing, so the state shall promote the principle of shared responsibility between workers and employers. So the goal of industrial peace is a shared responsibility of both the workers and the employers, not just by the employers. Okay? And the state shall also regulate the relations between workers and employers, recognizing the rights of employers, okay, the rights of employers to reasonable return of investment, and also the right of laborers to the just fruits of production. So there is a balance also. The the law and even the constitution, okay, they recognize the rights of both the employers and the employees. So the employees, they recognize the right of labor to just share of the fruits of production. On the other hand, the employers or the management, the company, they also have the right to grow, okay, to recover their return on investment, and to expand their companies, to expand their business. Okay, so this is provided under Section 3, Article 8 of our Constitution. And even on our labor code, so we have Presidential Decree 442, also known as the Labor Code. Okay, so under Article 3, it declares that the state shall afford protection to labor. Okay, even on the construction, or how do we interpret the laws, and even the uh, IRR. Okay, in case there are doubts in the implementation and interpretation of the law, okay, including the rules and regulations, it shall be resolved in favor of labor. So it is also referred to an equipoise rule, no? Equipoise rule meaning if there is doubt in construing or interpreting the law, okay, if there is doubt, only in case of doubt, no, the scales will be tilted in favor of the laborer, in favor of the employee. Okay, so that is basic, no, in how to interpret the law, labor laws, no. Okay, so just a quick rundown, no, or summary of what are the benefits, statutory benefits that are given to workers. We have first minimum wage, overtime pay, holiday pay, premium, night shift differential, 13th month pay, service leave, okay, Magna Carta for women, paternity leave for the fathers, the legal fathers, solo parent leave, no, solo parent act, violence against women and children. Then you have your retirement pay, okay, your separation pay, just in case you are you were terminated, no, from your work, okay, SSS, pag-ibig, and PhilHealth. So most of the lecture will come from also this handbook, no, handbook of workers statutory monetary benefits. Also would come from PD 442, the labor code. Okay, so if you would like to download the handbook, you can download it from bwc.dole.gov.ph. Okay. So what are the things to consider to determine if the statutory benefits we are discussing are applicable? First, we should determine if there is an employer-employee relationship between the parties. If there is none, then the benefits won't be applicable. So first, there should be an employer-employee relationship. We'll discuss that further. Also, we should determine the number of workers employed. Okay, do we have the company have 1 to 5 workers, 1 to 9 workers, 10 or more workers? And last would be the nature of the company. Okay, the nature of the company, no? So is the company engaged in agriculture, retail, or service? Okay, the different nature of the company. Okay. So how do we determine the first question, no? If there is an employee-employer relationship or employer-employee relationship. So we now go to the case of Rattan Incorporated versus Cumming. So decided on March 12, 2014. Okay. So according to the case, to ascertain the existence of an employer-employee relationship, to know if the worker is indeed an employee of the company, okay, we have what we call the fourfold test. Okay, the fourfold test. First, selection and engagement, the power to hire, the payment of wages, okay, the payment of wages, no, where does the payment come from, no? Does it come from the employer? Third, the power to fire or the power of dismissal, no? The power to fire. And last, which is the most important, is the control test. Okay, who controls the conduct of the employee? Okay, is it the company? Okay, so if all of these are present, then there is an employer-employee relationship. Okay, but out of the four, the fourth or the control test is the most important. Okay, so that is how we determine employer-employee relationship. Okay, so taking this from the handbook, the worker handbook a while ago mentioned, no? So you can see here the summary of the different um, statutory benefits and uh, the different number of employees and the nature of the establishment, no? If the benefit is applicable or not, no? So you can go to the manual for the summary. Okay. So first would be minimum wage. So what is a minimum wage? Minimum wage pertains to the lowest amount of wage that an employer should pay an employee, no? The basic, the minimum. So again, no, in the law, the law provides a minimum, the floor, not the maximum, not a ceiling. Because again, the employer and the employee can negotiate for the higher pay, no? How much would be the pay, no? If it but it should be higher than the minimum wage. So this is the current, no, minimum wage, no? Uh, so unfortunately, the last petition to increase the minimum wage was dismissed by the regional uh, tripartite wage and productivity board of NCR. No? So if you would like to petition for increase of wages, you go to the regional tripartite and productivity board. Okay, so that is where you petition. No? So it was dismissed. So our minimum wage remains the same. Okay, so for companies, there are some companies who are exempt from paying minimum wage. So these are the following companies that are exempted. So distressed establishments, so meaning those who are currently in the red, no? If you look at their income statements, they are uh, incurring a net loss in their income. New business enterprises, no? Specifically, if you are a BMBE or barangay micro enterprise, no? So you're also part, no? You are also exempted, no? Retail and service establishments employing not more than 10 workers. So if you are employed in this kind of a company and there are not more than ten workers, then you are not to be given a minimum wage. So the company is exempted. And establishment adversely affected by natural calamities. Okay? So the board may also exempt establishments other than those enumerated above only if they are in accordance with the rationale for the exemption. Okay? So these are the companies who are exempted from paying minimum wages. Okay? So one basic principle in labor law would be the no work no pay policy. Okay? So it means that, okay, so the court, according to this jurisprudence, no, so here we have Heilbronn Company versus National Labor Union. So in just a story, no. So here there was a strike, and because of the strike, some workers did not receive their daily wages, no, because they were on strike. Then after the strike, the employees were asking for back wages. They meaning they were asking the company to pay them the wages that they were unable to receive due to the strike. But however, according to the Supreme Court, no, let's read the decision, as to demand for payment of wages that the strikers lost on the occasion of their strike on November 22, 1948, the court understands that a strike is a voluntary and deliberate cessation of work on the part of the workers. Upon this consideration, and based on the equitable tenet of a fair day's wage for a day's labor, this demand falls of its own weight and must be as it is hereby denied. So it was denied. No? So the principle of no work, no pay policy, okay, it means that a fair day's wage for a fair day's labor. So if you gave a service or if you worked for that day, then you deserve to be paid, no, for that day. Okay, so no work, no pay policy. Okay, so that this in the case of Heilbronn Company versus National Labor Union. Okay, so they cited that case, no, in San Miguel Brewery, also versus National Union. Okay, but what if it was due to a lockout, no? So we also have a distinction, no? So for strikes, no, the wages that were lost is not to be paid, okay? But on for this case, no, Response versus Minerva M. Pacheco, so decided in January 25, 2012, if there is no work performed by the employee, there can be no wage or pay, unless, so there are exceptions. Of course, the laborer, the employee was able, willing, and ready to work, but was illegally locked out, dismissed, or suspended. So the no work, no pay principle contemplates a no work situation where the employee voluntarily absents themselves. So if um, the non rendering of service or work was involuntary, okay, it meaning it was not due to the fault of the employee, then there can be a no wage or no pay policy. Okay, so that is the difference, no? Okay, so no work, no pay policy. Okay, so we now go to our first benefit, no, provided under law. So we have overtime work. So under Article 87, okay, so work may be performed beyond 8 hours. Okay, it may be performed, no, may meaning it is not mandated, no. So 8 hours a day, and an overtime work should be paid additional compensation equivalent to 25% of the wage, the regular wage of the worker. Okay, so that is the how we compete for overtime work. So work beyond performed beyond 8 hours on a holiday or rest day. So if it was performed, no, overtime work performed during a holiday or a rest day, okay, it will be at least 30%, no, of the regular wage of the employee. Okay, so again, no, so as HR practitioners, no, as part of the payroll, no, if you're under compensation and benefits, no, that department, so you need to determine, no, if it's overtime work, okay, on a regular day or overtime work rendered during a rest day or a holiday, no, because the percentage would be different. So with regard to overtime work, overtime is not presumed, no? It is not presumed, no? So we have here another story, no, another case, no? So the case is Stolt Nielsen Marine Services versus NLRC. So this actually is a story about a seafarer, no? A seaman, no? So here the employee was asking for overtime pay because according to him, being in a ship, no, inside a ship, he was not allowed to go home and he was forced to stay inside the ship, no. So that is the background of the case, no. However, the Supreme Court said, it simply stated, the rendition of overtime work and the submission of sufficient proof that the said work was actually performed are conditions to be satisfied before a seaman could be entitled to overtime pay, which would be computed on a base of 30% of the basic monthly salary. So it should again be proven. So not just because you're inside the ship, no, and you're not allowed to leave the ship, of course, for obvious reasons, that it would entitle you to overtime work. Okay, for the seaman to be qualified to ask for overtime work, okay, the proof of service should be proven. Okay, meaning he should be able to prove that he actually rendered overtime work, no, during those times. Okay, so that is for the case, no. Okay, so some uh, other statutory benefits provided by law. So we have compensation of rest day, okay, Sunday or holiday work. So where an employee is made to permitted to work on his scheduled rest day. So this is considered a premium pay and holiday pay, no? So rest day, he shall pay an additional compensation of at least 30% of his regular wage. Okay, so aside from the payment during his rest day, he shall receive an additional 30%, okay, for working during his rest day. Okay. So an employee shall also be entitled to additional compensation for work performed on Sunday only when it is his established rest day. Okay. So if Sunday is the rest day of the employee, he's also entitled, no, to 30% premium pay or okay. So continuation, no. So work performed on any special holiday shall be paid additional 30%. So that would be for a special holiday. But if such holiday work falls on the employee's scheduled rest day, meaning so the work was rendered on a holiday, a special holiday, and the rest day of the employee. For example, the special holiday was on a Sunday, and the Sunday was also the rest day of the employee. Okay, he shall be entitled to an additional compensation of at least 50% of his regular wage. Okay, so if the work rendered, okay, it fell on a special holiday and the rest day of the employee. Okay. So what about night shift differential? So if you're going to work in a BPO and your shift is during the evening, so you are entitled to this pay. So according to Article 86, every employee shall be paid a night shift differential of not less than 10% of his regular wage for each hour of work performed between, so this is a threshold, 10 o'clock p.m., 10 p.m. to 6 o'clock a.m. Okay, so that's the threshold. So if you work between 10 a.m. to 6 a.m., okay, you will be entitled to night shift differential. Okay, so again, no, these are minimum, no. So if the company is more generous, then the company can provide a higher pay, okay, premium pay or night shift differential pay. Okay, so right to holiday pay. So this pertains to the regular holidays. So these are holidays established by law. Okay. So every worker shall be paid his regular daily wage during regular holidays, except in retail establishments regularly employing less than 10 workers. Okay. So that is the exception. Okay. So regular holidays, meaning these are determined by law. Okay. So the employer may require an employee to work on any holiday, but such employee shall be paid a compensation equivalent to twice his regular rate. So meaning, if it is a regular holiday and the employee did not work because it is a holiday, is entitled to 100% of his wage. Okay? But if the employee was required to work during that regular holiday, then he will be paid a compensation equivalent to twice or 200% his regular rate. Okay? So what are the um, regular holidays, no, as mandated by law? No? So we have here New Year's Day, okay, during the Holy Week, Monday, Thursday, and Good Friday, April 9, okay, Araw ng Kagitingan, the 1st of May, Labor Day, the 12th of June, okay, June 12th, Independence Day. So before it was July 4th, no, the Philippine-American Friendship Day, but now it's no longer a holiday. Okay, the 30th of November, the 25th and 30th of December. Okay, Rizal Day. Okay, so and the day, of course, designated by law for holding a general election. No? So this will be next year, no, when hopefully we have our presidential elections in 2022. Okay. So if you have questions, so you may type it in the chat box, no, for the Q&A later. Okay. So what is salary differential? We now go to salary differential, no. So in case the minimum wage rate, okay, or any any difference between the minimum wage rate and the actual wage paid to employee, if there's a difference, okay, you can call it salary differential. So this should be paid by the employer to the employee, no? The salary differential, the discrepancy or the variance between the actual wage paid and the minimum wage rate provided by law. Okay, so according to the case of Minsola versus New City Builders, okay, so in claims for payment of salary differential, service incentive leave, the holiday pay, 13th month pay, the burden of payment will rest on the employer. Okay, so that is for salary differential, service incentive leave, which we'll be discussing later, and the 13th month pay. So the holiday pay. So the burden of proof will be on the employer. Okay. But with regard to overtime pay, premium pay for holidays and rest days, the burden is shifted on the employee, as these are monetary claims that are not incurred in the normal course of business. So it's the employee who will prove that he actually worked overtime, he worked during his rest day or a holiday, okay, to be qualified to claim these premium pay, no overtime pay, these kinds of wages. Okay, so because it is not based on the normal course of business of the employer or the company. Okay, but for again, no, for the normal kinds of pay, no, the salary differential, meaning if the minimum wage was not paid, service incentive leave, okay, the holiday pay, the 13th month pay. So the burden of proof is now with the employer. Okay. So what is the 13th month pay, no? So, some of you know this as the Christmas bonus, no? Okay. So it's actually not anymore considered a bonus because it is already mandated by law. Okay, basically if it uh, talk about a bonus, no, it is something that is not mandated by law, but due to the generosity, okay, of the employer, they gave a bonus to motivate their employees. Okay, so the 13th month law is based on PD, Presidential Decree 851, no, during because before the president, no, during the time of President Marcos, he also had legislative powers, no, not right, not like today, wherein the power to enact laws is vested in Congress, meaning the House of Representatives and the Senate. Okay, before, during that time, the president also had the power to enact laws, no, by decreeing, no, presidential decree. So under PD 851, okay, payment of 13th month pay. So all employers covered by the presidential decree, okay, as referred to, shall pay all their employees receiving a basic salary of not more than 1,000 a month at 13th month pay, not later than November 24 of every year. Okay, so it was called the Christmas bonus. Why? Because the main reason or rationale for this bonus or this pay, 13th month pay, is to help Filipinos, because of our economic situation. Then the president would like to give additional funding for Philippines to celebrate Christmas. No? For us, no, Filipinos, especially being a Christian Catholic country, no, for 400 years already, no, we celebrate Christmas. To celebrate Christmas, okay, they mandated the employers to pay the 13th month pay not later than December 24, no, Christmas Eve, for us to be able to celebrate. No? So what do we mean by 13th month pay? So it means that it shall be 1 over 12 of the basic salary of an employee within a calendar year. No? So you compute the annual salary of the employee, 1 calendar year, then you multiply it by 1, then divide it by 12 no, to compute for your 13th month pay. Okay, so it should be paid again, no? Not later than December 24. Okay, some companies they divide it no to help their employees during the tuition fee season, okay, during June, no? Because June is actually the official start of classes in the Philippines. So some of the employers they give the option, okay, they ask their employees if they would like to avail of the 50% of their 13th month. No? So they divide it into two, okay, to help the to help no the academic expenses of their employees. Okay? So what if the benefits have already ripened no into management practice no? For example, there is this one company, they actually gave bonuses already no, aside from the 13th month pay, they were giving 14th month pays no, or 14th month bonuses to their employees no. Then suddenly they tried to remove it no. So what would happen no, according to the Supreme Court decision, the company can no longer withdraw it if that practice already has been ripened no into a management practice. Okay, so it is under the principle that no benefit and supplement being enjoyed by the employees cannot be reduced, diminished, discontinued, or eliminated by the employer. Okay, so under the principle of non-diminution of benefits. No? So it can no longer be reduced, diminished, discontinued, or eliminated no, by the employer. Another case like this was the case of RCBC Union, Bank Card Union. No? Sorry, I think it's Bank Card no? Union. Because in their company, no, in the Supreme Court decision, the management, when it was taken over by a new owner, they wanted to reduce the lunch break. Okay, because the lunch break being enjoyed by the employees was actually 1 hour and 30 minutes. No? That was the lunch break. So there was a new management who acquired the company, the bank card company. Then they were trying to reduce it to 1 hour, to be probably they would like to make it uniform, uh, across all of their different business units, their different group of companies on 1 hour. However, according to the Supreme Court, it can no longer be discontinued. No, it is already ripened as a management practice. So it is already okay a benefit that cannot be discontinued or diminished. No, non-diminution of benefits. Okay, so let's continue. So we have here the service leave, maternity leave, and Magna Carta for women. So what is the service incentive leave? So this is also under Article 95 of the Labor Code. So according to the article, every employee who has rendered at least 1 year of service, so every employee, no, regardless if you are a contractual, a seasonal, regular, regardless of employment, but every employee who has rendered at least 1 year of service shall be entitled to a yearly service incentive leave of 5 days with pay. Okay, so 5 days. So, but if the company already has a benefit, no, for example, sick leave and vacation leave, then it will already suffice. No? It will take the place of the service incentive leave. No? But if there are no leaves being given by the company, okay, then the service incentive leave will apply. Okay, so right now there are already moves in Senate. No? I think there was a bill filed by Senator Villanueva to increase the service incentive leave to make it 10 days. No? Because according to him, um, some employees who are not regular employees, 5 days a year is too small, for them to be able to live, have a decent life, because 5 days a year, it's not enough, for them to attend to um, when they get sick, So that's according to Senator Villanueva. Okay, so we also have the special leave benefit for women, no? So this are for all women, no? So we call it the Magna Carta for women, no? Not just for married, no? It is also pertains to single women, no? But with regard to the move for the Sogi bill, no? I'm not sure how will it will affect this law, no? If they allow, no, uh, transgenders or the trans women to be considered as legally as women, no? But of course, that is a separate discussion, no? So we'll dwell on the Magna Carta for women. Okay, so a woman employee having rendered continuous aggregate employment, okay, service of at least 6 months for the last 12 months shall be entitled to a special leave benefit of 2 months with full pay based on her gross monthly compensation following surgery caused by gynecological disorder. Okay, so for example, no, uh, if a woman, no, gets operated because of myoma, no, so even if she is not married, she'll be entitled to this special leave benefit. No, so it is for the Magna Carta for women. Okay, so we have here the Solo Parents Welfare Act. Okay, so solo parents, no? So solo parents are entitled to flexible work schedule. So the employer shall provide a flexible working schedule, okay, for solo parents. And the solo parent shall also have a parental leave. So in addition to the leave privileges under existing law, so these are additional leaves, no, provided to the single parent. So the parental leave of not more than 7 working days every year shall be granted to any solo parent employee who has rendered a service of at least 1 year. Okay? So this is the solo parents leave, no? So if you're a solo parent, so being a solo parent to allow you to attend to the needs of your child, no, to for example, no, you need to attend graduation, the parent parents and teachers association meetings, so and being the solo parent, okay, uh you need to attend it, so you are given this kind of leaves, no? So that is the reason behind it. So again, parental leave, no, solo parent leave, 7 working days, so every year. So we now go to the fathers, no? So I think 2 weeks ago we celebrated Father's Day, no? So we have RA 8187 or the Paternity Leave Act, no? So these are leaves, no, provided to our fathers, no? So notwithstanding any law, rules, regulations to the contrary, so every married male employee, so the male employee should be married, so legally married, so that's the first requirement. The male employee first, male, and he should be married in both the private and public sector, shall be entitled to a paternity leave of 7 days with full pay for the first 4 deliveries of the legitimate spouse with whom he is cohabiting. So for the fathers, no, should you first you should be married, no? Then it is only what for the four first 4 deliveries, no? And it should come from your legitimate spouse, no? It should not come from other sources, no? And you must be cohabiting with your legitimate spouse, no? Okay, so these are the requisites, no? What if the father is not legally married, no, to the mother? So what would happen? What would happen? No, we'll discuss that later in the expanded maternity act. No, that will be addressed later. So after this law was enacted, probably there were questions also. No, what would happen, no, for fathers who are not legally married to the mother? Okay, that will be addressed later. Okay, so we now go to the VAUSI law. Okay, the Anti-Violence Against Women and Children Act of 2004. So who are entitled to leave, no? So victims under this act shall be entitled to take a paid leave of absence up to 10 days, no? So 10-day leave, no, of absence paid. Okay. In addition, so this is additional leave, no, to other paid leaves under the labor code and civil service rules, no. So additional leave, no, and regulations. Extendable when the necessity arises as specific in the protection order. So the court can actually declare a protection order which will extend the entitled leave, no, to more than 10 days. Okay, so why? Probably if the woman was the injury suffered would require it, no? Okay, so any employer who shall prejudice the right of the person under this section shall be penalized in accordance with the provisions of the labor code and civil service rules, no? So okay, so the victims, okay, the victims of uh, violence against women and children are given this special leave, no? So don't forget, no, the VAUSI leave. Okay. So we now go to the expanded maternity leave, no? So RA 11210. Okay. So it is the coverage, or it is effective for all female employees who gave birth starting March 11, 2019, no? So that is the cutoff. So what is the expanded leave, no? So 105 days paid leave for live birth. Okay. So the 7 days are transferable to the father. So regardless if you are a legitimate or illegitimate, legitimate or illegitimate father, you can transfer the 7 days, no, leave, no, to the fathers, no. So for example, I am the legitimate father, so I have already 7 days paternity leave. Then I can what request that 7 days leave from my wife be transferred to me. That can be done, no, under the law. But of course, the decision maker for that would be the wife or the mother. Why? Because it is her benefit. The wife can choose, no, she can choose to transfer it to the father or not to transfer it to the father. Okay, so that is the 7 days leave transferable to fathers. So additional 15 days for solo parents, no, under RA 8972 if you are a solo parent. Okay, then you have the option, the mother, okay, has the option to avail of the 30 days additional leave without pay. Okay, so you can avail that, no. Okay. Okay, so that is for live birth, no. So if the baby was born and it was declared, okay, alive, okay, by the doctors. Okay, but for miscarriages, emergency termination of pregnancy, for example, uh, you need to abort, no, the fetus, no, because due to the danger in the life of the mother, no. So it will be 60 days. Okay, so 60 days lang siya. Okay, so this is the maternity expanded maternity leave. Okay, so we now go to separation, no, separation from service, no. After the employee has separated from service, of course, he also still has some benefits, no. He is entitled to some benefits from the employer. So one, we have the retirement pay. Okay, so Article 287 under the Labor Code, retirement, any employee may be retired upon reaching the retirement age established in a collective bargaining agreement or other applicable employment contract. For some companies, their mandatory retirement is 60. For others, it will be 65. No, for some professions which are, for example, those who are working in mining companies, the miners, they have an earlier retirement, no, at most 55, no, you retire at the age of 55. Okay, so 60 years or more, but not beyond 65. So you are what? You are qualified to receive, okay, retirement pay. So it will depend on the collective bargaining agreement or the employment contract. Okay. But if there is none, okay, the employee shall be entitled to retirement pay equivalent to at least 1/2 month or 150% okay, of your monthly salary for every year of service. So a fraction of at least 6 months being considered as one whole year. For example, I worked in the company for 20 years and 10 months or 20 years and 7 months. So that will be considered 21 years. So multiply it by uh, so if I'm receiving a salary of 50,000 a month, okay? So that will be 50% of 50,000 will be 25,000 times multiplied by 21 years of service, then that will be my retirement pay. Okay, so that would be the minimum. Okay, if there is no retirement plan or agreement in the CBA or in the contract, but if there is an agreement which is higher, then that will prevail. No, some companies, no, especially right now because of the pandemic, they are offering early retirement to their employees, no, and to encourage their employees to avail of the early retirement or the voluntary retirement. Okay, they make it bigger, no. There is one company who gave 200%, no, to their employees, meaning if they worked for 10 years, okay, and they are earning 50,000. Okay, so for every year of service, they will be paying you 100,000. So that will be 1 million, no? So to encourage the employee to avail of the voluntary retirement pay. Okay, so because of the pandemic, no? Okay, so what would happen if the company suddenly closes, no, becomes bankrupt, no? So a lot of companies right now, especially those in the hospitality and tourism, okay, airline companies, hotels, restaurant, they are what? Closing their companies, their business establishment. So, what are the rights of the employee? Okay, so the employer may also terminate under Article 283 of the Labor Code. Okay, so the employer may also terminate the employment of any employee due to installation of labor-saving devices, redundancy, retrenchment to prevent losses, or the closing or cessation of operation of the establishment. Okay? So, first, they should need to serve a notice to the Department of Labor and Employment at least 1 month before the intended date thereof. Okay? So, if the worker was terminated from work due to installation of labor-saving devices or redundancy, the worker shall be entitled to a separation pay equivalent to at least 1 month of his salary, okay, for every year of service. Okay. In case of retrenchment, to prevent losses, or in case of closures or cessation of operation, no? For example, the restaurant had to close. For example, one restaurant had to close their branch, no, to prevent, or to they had to reduce their manpower because of the reduction of customers or sales, no, they can retrench their employee, but the employee is what, still entitled to receive, no, to 1 month pay. Okay, to equivalent to 1 month pay or at least 1/2 month pay for every year of service, whichever is higher. So 1 month pay if his service to the company is less than 1 year. Okay, but if it is more than 1 year, for example 3 years, then it should be 1/2 month for every year of service, no? So it means that the employee, okay, should be able to collect, no, from the company, no, especially right now because of this pandemic, no. I have a lot of clients who are asking help from me, no, employees, no, who are asking help from me, okay, because they were just dismissed outrightly by their employer, no, without any separation pay. Okay, but under the law, if the closure, okay, was not due to serious business losses, the employer should pay separation pay. Okay, so what are now serious business losses, no, to exempt, no, employers from paying separation pay. Okay, so we now go to the case of GJT Rebuilders Machine Shop versus Ricardo Ambos, no? Decided in January 28, 2015. Okay? So the only time employers are not compelled to pay separation pay is when they close their establishments or undertaking due to serious business losses or financial reverses. So meaning the losses should be serious and not just be minimal or de minimis. So serious business losses are substantial losses, okay? Meaning that the business must have operated at a loss for a period of time, okay? For the employer to have perceived objectively and in good faith that the business financial standing is unlikely to improve in the future. Okay, so it means that the company can no longer recover. So, continuing, so the burden of proof, okay, that serious business losses were incurred by the employer is on the employer. Okay, the employer must show losses on the basis of one, financial statements covering a sufficient period of time. Okay, so it should not just be for 1 year, especially for this pandemic. Now we're only 1 year, no, 1 year and a half, no. So it must not just be for this pandemic, but it should also be for what? It should be serious and it should be for a specific sufficient period of time. Okay. In the case of North Davao Mining Corporation versus NLRC, North Davao Mining presented evidence, financial statements, meaning audited financial statements that you submit to the Securities and Exchange Commission and to the BIR, that the continuing pattern of losses was from 1988 until its closure in 1992. So the company suffered net losses averaging 3 billion a year, with an aggregate loss of 20 billion by the time of its closure. This court, the Supreme Court, found that North Davao suffered serious business losses, no, and they were not compelled to pay separation pay. Okay, so if you would ask me, no, personally as a lawyer, what would I do? No, for example, I have clients, no, who were not given separation pay. How will I prove that the employer is liable to pay? Then I would ask them to present their financial statements, okay? Specifically their income statement to get to look at their income, their net income for the past 3 to 5 years, their cash flow statement, okay, showing their ending cash balance for the year, meaning how much cash do they have, and in their balance sheet, I will look at the retained earnings of the company. Okay, in their equity portion, no. So that would help me as a lawyer prove that the company is not really suffering serious business losses, no. So okay, so some labor advisories, no, released by Dole, no, especially during this time of pandemic, no. So according to Dole, no, instead of outright retrenchment or termination of service of their employees, no, so companies are encouraged to do the following practices, no. So they can do telecommuting, work from home arrangements, no. They can do also job sharing, and also forced leave, no. What do you mean by forced leave? So for example, the company provides a leave benefits, no, for vacation leave. Okay, some companies they provide 10 days vacation leave to their employees. So the company can mandate employees to use their vacation leave, no. So that can be done, no? Because some companies, if you don't use the vacation leave, you can convert it into cash. So according to the DOLE, Department of Labor and Employment, no, the company can use forced leaves, no. Also, they can also rotate workers, no, job sharing, to help the company survive, no, during this pandemic. Okay. So another labor advisory. So these are series of 2020. No, basically it's still new. Okay. So suspension of employment relationship, meaning putting workers in floating status. Before, okay, prior to the pandemic, okay, workers are only allowed to be placed on floating status. So for example, the security guards, they're allowed to be placed on floating status without pay for 6 months. No, okay, suspension of relationship. But for because of this pandemic, the Department Order number 215 series of 2020 extends this to another 6 months, no? So it will be extended, no? So that is the gist, no? The summary, no? So the extension of suspension of employment shall not affect the right of employees to separation pay. The first 6 months of suspension of employment shall be included in the computation of the employee separation pay. So after the extension, no, if the employee cannot still be reinstated, no, then he shall be entitled to separation pay. Okay? So this is for Department Order 215 series of 2020. Okay, so again, I think this is a very hot topic, no? So last year, rather last March, there was a labor advisory on last March 2020. So series of 2021, no? So last March 12, no, 2021, the Department of Labor and Employment, okay, advised employers that uh, the no work, no vaccination policy is not allowed, no? So according here, no, um, the no vaccine, no work policy shall not be allowed. No? So this was released by Dole. So meaning, if you are an employee, you are a laborer, no, you cannot be forced by your employer to get vaccinated, no? Especially for COVID-19. Okay? And if you would be vaccinated, okay, it should be charged against the employer. Okay? So you cannot be forced to get the vaccine, COVID-19 vaccine, according to the Dole Labor Advisory, no? This was just last March, no? Barely 3 months ago, March 12, no? Okay? So you cannot be forced to be vaccinated. And if you would like to be vaccinated, the payment for the vaccines should be shouldered by the employer. Okay, so this for the COVID-19 vaccine. No? I won't comment on the declaration of the president. No? I'll just leave it to the Senate, the Supreme Court, no, to decide. No? Okay, but according to the Department of Labor Advisory number 3, series of 2021, no, which is a written document, no, uh, the no vaccine, no work policy shall not be allowed. Okay. So in case the employee gets terminated, no, so we have here the final pay and issuance of certificate of employment. Okay. So the final pay of the employee should be paid 30 days from the date of separation. Okay. So it should not be more than 30 days. It can be earlier than 30 days after the separation, but it should not be longer than 30 days. And if the employee will ask for a certificate of employment, okay, it should be issued by the HRD of the company, okay, 3 days from the time of request, no? So it should not be greater than 3 days, no? Okay, so if I suggest, no, if you start working in a company and you transfer to another employer, okay, that's my suggestion, no, always keep your certificate of employment, no, for all of the companies where you work, no. Why? Because you need it as your proof of employment, no, especially if you go to the academe or if you would like to go abroad. Your proof of employment will be your certificate of employment, no. Even if you put it in your resume, the work experience, but you don't have a certificate of employment to prove it, then it will not be honored, no, by the company. You should be able to issue a present a certificate of employment, no. So that is very important. Okay. So again, no, the final pay should be 30 days, no, after the termination of employment. So meaning if my Last day would be today in work, no? June 30th. For example, I resigned from my current job today, June 30. Okay. After 30 days or before July 30, I should be able to get my last pay. Okay. What about the clearances, no? The the clearances needed, no, in the company. Okay. The clearances that you need to get in from the company should be made, okay, before your last day. No, that should be that is the most prudent practice, no, for both the company and for both the employee. Why? Because if you are the employer, you don't want a former employee entering your company after his last day for security reasons, no? So you don't want a former employee entering your company, no, loitering inside your company, okay, after his last day. And on the same day, no, if you are an employee, you would like to what? Settle off all of your accountabilities in your company, okay, before your last day, so that you can move on to your next employer, no, after that. You no longer need to uh, fix your clearances, no. Okay, so that is the most prudent way, which is both beneficial for both the employer and the employee. And also, it will what? Adhere or follow the labor advisory given by DOLE. That the payment of the final pay, the release of the final pay should be 30 days from the date of separation or termination. Okay, if you would ask me, if I were the manager, the HRD manager, I would require the employee to complete all of the clearances, turn over all of his accountabilities on his last day. Okay, even the everything, the ID, the his password, no, his laptops, you turn it over to the company on your last day. Okay, so our last mandatory benefits, we have social security system, pag-ibig, and PhilHealth. Okay, so this we are now going to end the lecture. No? So the Social Security Act is actually for the private sector. For the public sector, you have your GSIS. No? I think the military, the AFP, they have also their own. Okay, so we have here the main goal, no, so of the Social Security Act is to develop, promote, and perfect a sound, viable, tax-exempt social security system suitable to the needs of people throughout the Philippines. No? So it means that for you to be secure, for you to have a source of income, no, after you retire, you need to make the contributions now while you are working. And the social security system would be the fund manager to collect the payments and to invest your payments to make it grow, so that when you get old, okay, you will have a source of your pension. Okay, so this is one of the government mandated deductions from the salaries of their employee, or the salaries of the employee, no, SSS. So same same with the contribution of the employee, the employer also has his contribution to the social security system, no, fund, no. So we have both the employee contribution and the employer contribution. So depending on your contribution, okay, it will also determine your benefits or the pension that you will have, okay, in the future. Okay, so we now go to PD 1752, or the Home Development Mutual Law Fund, okay, which is actually promoting, no, socialized housing. So it state policy, okay, it is the policy of the Republic of the Philippines to motivate the employed and other earning groups to better plan and provide for their housing needs, no, by membership in an integrated nationwide saving system. So the main goal of this, no, pag-ibig, no, your pag-ibig contribution is for you to be able to buy your own house, no. As we all know, if there is an American dream, we also have our own Filipino dream, no. We Filipinos are very simple, no. We are contented with two things, no. One, to put our children, to give them the best education, to put them to college, to allow them to graduate in college. Okay? And second is to have our dream house, no, our own home. Okay, a house that we could call our own, no. So that these are the two basic or very simple dreams, for a Filipino. Okay, so that is our Filipino dream. So to help us achieve that dream, that goal, so we have the Home Development Mutual Fund Law, or what we all know as Pag-ibig. Okay? So I saw this joke, no, in the internet, no. There was this worker, no, employee, worker, laborer, no, with the coat, no. He was working and there was a coat, no. In Filipino, so ang pag-ibig hindi na pinoproblema yan. Kasi monthly kinakaltas ng kinakaltas yan monthly sa empleyado, no. So yun yung joke nila. Okay? So last benefit will be the PhilHealth, no, or the National Health Insurance Act, no, the PhilHealth. So here we have the goal of the government is to provide universal health care or socialized health care, no. So they would like to provide health care to all Filipinos. So your contribution to PhilHealth, before it was the same, no. I remembered when I started working, it was 100 year, no, 100 a month, no. But now it will now depend on your income, no. For those who are earning higher, you need to what? Contribute higher to the National Health Insurance, okay, or PhilHealth, no. Okay, so it's a social service, no, to make essential goods and health and other social services available to the Filipino, especially to the pauper. So since you are earning more, you need to also what? Contribute more, no? So that what you call it a progressive system, no? So similar to taxation, the higher your income, your taxes will also be higher. So it is also the same principle, no? So that is for the National Health Insurance Act of 2013. Okay. So again, no, I think that ends my lecture, no, everyone. No? So thank you again for this opportunity. So thank you, Sir Joseph, no, and God bless.
Thank you, Attorney Miguel. Mm. Just 1 second, please. If we have questions dun sa mga estudyante natin from RTU, you can type dito sa chat box, then I'll read it. Gallery speaker. We have one here, attorney. Attorney, ask ko lang po, considered po ba na regular employee ang isang employee na nag-work na ng 1 year pero walang pinirmahan na contract for regularization? Ang pinirmahan niya lang is contract for 6 months nung ma-employed siya. Mari po ba niyang request sa employer niya na mag-grant yung service incentive leave na 5 days even if walang pinapirma sa kanya na papers for regularization? What if hindi i-grant yung ng employer, ano po ang pwede niyang gawin?
So automatic, no? If you were not given a regularization contract, say usual, management practice, no, when I was in the industry, after the 6 months probationary period, before actually the 6th month, okay, there would be an evaluation conducted by the superior and the employee. So the superior will the superior or the supervisor will what? Evaluate your performance, and he or she will inform you if you will be regular or not, no? Sometimes there will be agreement to even extend the probationary period, no? Pwede yun, no? Extend yung probationary period, no, to another 3 months, no, or so. But pagka wala, automatically after the probationary period of 6 months and you continued your employment, okay, you're already deemed a regular employee. Okay? I know a case before, no? OJT pa nga lang, no? OJT, on the job trainee, no? Ng school. Pinagtrabaho sila. I think it was a hotel, no? Hotel yata siya, no? So, after 6 months, no, OJT niya 6 months, no? After nun, tinuloy ng employer. Tapos after nung 6 months, so nag-file ng ng case sa DOLE yung mga estudyante kasi may tito yata na lawyer, no? Sinabihan sila, regular employee na kayo kasi 6 months tinuloy niyo yung OJT niyo, no? And they actually won, no, the case, no? They were deemed regular employee. So, for the service incentive leave, no, yung second question, regardless if you are a contractual employee or a seasonal employee, casual employee, as long as you rendered for more than a year, no, at least 1 year of service, you are entitled to the service incentive leave of 5 days. No? So kahit contractual ka lang, kahit ni-renew ulit yung contract mo, another 6 months, so naka 1 year ka. So you are entitled to that service incentive leave, no? But make sure na wala ka ibang leave na kukuha. Kasi if you have already the vacation leave or the sick leave, that will take the place of the service incentive leave, no? Equivalent na siya doon. Okay? But if wala, you don't have any leave, no? And you would like to claim the service incentive leave, you can ask DOLE, okay, to inspect, no, to visit the company. You can file a complaint in DOLE to inspect and visit the company. So check ng DOLE 'yon, no. Titingnan yung books ng 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 company, no. Actually hindi lang yung service incentive leave mo, lahat ng mandated benefits, so they can actually check it if the company is complying with it. Okay?
Dahil doon mabubuklat pa lahat ng tinatago kung meron man. So, mga ito kasi attorney, mag-OJT ngayong, or tapos na yung OJT. Hindi, mag-OJT sila ng second sem ng fourth year nila. Next question, attorney. What are the legal instances where illegal dismissal is declared but back wages are not awarded?
Illegal. Actually, it will depend on the facts of the case, no? Basically, back wages are awarded, okay, or separation pay is awarded when the employer and employee relations were strained that it can no longer be restored, no? Hindi na pwedeng ibalik sa dati. Yung talagang very uncomfortable na si employee na mag-work doon, bumalik, no? Nasira na yung relationship na hindi na siya pwedeng ibalik, no, na damage na yung relationship. So separation pay na lang. As for back wages, so if the employer, okay, prohibited the worker from working, okay, di ba, dapat di ba, if it's voluntary na hindi nagtrabaho si worker, okay, going back to our no work no pay policy, back wages, okay, is not to be awarded, no. But if the employee is available and is willing to work, but the employer prevented him or her to work, okay, illegally, then back wages should be awarded. Yun yung principle lagi, no? So, sa no work, no pay policy and awarding of back wages.
Thank you, sir. Another question, follow-up niya siguro to. The stipulation of the parties in the contract prevail in determining the employee-employee relationship or the employment status of the employee? Contract prevail.
Basically, no, under obligations and contracts, no, the contract is the law between the parties. But if there are provisions under the contract which are good morals, public customs, no, then it can be declared void, no, by the court. So it will also depend, no? But basically, the general rule is that the contract is the law between the parties. So yung contract pa rin ang magpe-prevail, no? Because that would be the best evidence, no, sa natin yung rule, di ba, yung parang yun yung pinakamagandang ebidensya mo, no, sa papakita mo pagka may dispute yung kontrata, because it is written, no. But of course it can still be disputed, no. Pwede may mga witness ka, no.
Okay, thank you, sir. Jeric, please pa-co-host si Mr. Harold Fernandez. May mga pumapasok daw. Although wala tayong nakikitang pumapasok dito sa gilid, baka kasi hindi natin nakikita. Thank you. Sir, pag nag-resign daw ba, immediate resignation ay may back pay?
Wala kasi voluntary siya, no. Makukuha mo if you resign, since it was voluntary termination of your employment, no, you will get your prorated 13th month, no, and of course your unused VLSL and the pro rata income, no? Yung pro rata salaries mo for that month.
Thank you, sir. This one, ask ko lang po since pandemic ngayon, and marami ang floating status, what actions they should do if ever they encounter another agreement to other company without the consent of their present employer. Kasi di ba po sobrang ng panahon ngayon ay di kayang maghintay ng 6 na buwan para tumambay. So meaning may previous agreement siya para but hindi pa siya nakapag-start siguro, then he or she is accepted na dun sa bago niyang in-applyan, parang ganun ba ang context, no, sir?
Hello po. Sir po, pwede po mag-ask po.
Yeah, please. Ikaw si Mr. Ray Rosandal, right?
Yes po, sir.
Okay, sige.
Kasi po may nababasa po kasi akong issues that there are employees who are in a floating status, and then syempre po hindi po sila makapaghintay na to work because of this situation, walang pera. And then pumasok po sila sa another agreement, which is nag-work po sila with the other employer pero wala po binigay na consent po doon sa present employer po nila. So what actions are they going to do po para po ma-resolve po yung problems?
Sige, let's wait lang. Baka nag-lag lang si attorney.
Series of 2020, no? May provision siya. Merong provision that Hello, yes sir. Sir, clear na ba ako, sir? Clear na?
Yes, sir. Yes, sir. Now, you can start.
Yan. Okay. So, there's also another provision, no, under yung Department Order 215, Series of 2020, regarding suspension of employment relationship. Okay, there is a clause, no, that says, okay, the extension of suspension of employment, okay, provided however that the employee shall not lose employment. So yun yung yung may exception siya, no, that the employee shall not lose employment if they find alternative employment during the extended suspension of employment, except in cases of written, unequivocal, and voluntary resignation. So, yung 6 months na yon, hindi pa pwede. After the 6-month period na floating, tas na-extend si employer, then the employee was able to get alternative work to survive, no? It will not remove the security of tenure of the employee provided hindi siya nag-resign. Walang express resignation, no, sa employee. Okay?
Thank you, sir. What are the actions from Ray to be done by the employee aside from updating the HR about the delay of giving COE? For example, 1 month na delay na. Paano bang gagawin natin, sir, dun sa mga ayaw talagang mag-release ng COE kahit wala namang reason para hindi i-release ang COE ng mga former employees nila?
You can always go to the DOLE, no, to complain, no. Pwede siya laging i-complain sa DOLE because that is already defying the order of the Department of Labor and Employment, no. May mga help desk naman ng DOLE wherein you can give your complaints to.
Yun. Next po, sir, regarding doon sa premium pay, particularly po doon sa pag nagkasabayang special holiday at rest day. Di ba po entitled si employee for additional pay of 50% of his basic wage pag pumasok siya? What if po absent siya before that day? Applicable pa rin po ba yun? Thank you po. Sige po, sir.
For the holiday pay, no, may requirement kasi siya that you should be present the day before, no, especially pagka long weekend, no, kasi ang ginagawa ng ibang employees, no, they look at the calendar, nakita nila long weekend, nag-a-absent sila para mas humaba, no. So there are actually policies, no, dapat talaga pumasok, no, before the week prior to that. If you don't go to work, no, prior to that holiday, then you won't be entitled to the holiday, to the pay.
Thank you, sir. Dito, sir, ano daw ba yung timeline na makapag hulog ng company benefits, especially ngayon nga pandemic? or paano yun kung na-delay yung paghuhulog?
You can always complain with the DOLE, no? Kasi especially for SSS, if you don't remit SSS, that will be considered a criminal offense already, no? Actually, there are a lot of companies, no, wherein may mga clients akong gano'n, no, their employees were charged with qualified theft, no, kasi nagnakaw, nakapuslet, no, then suddenly the employee will counter non-payment of SSS benefits, so kulong din pareho, so nagiging leverage pa ng employee. So it should be reported to the SSS, no, yung mga non-compliance. So it's actually considered now may penal provisions na siya. If you look at the new SSS law, it was made stronger, no, by law.
Thank you, sir. Ito medyo madami ang question ni Mr. Legally Ranmark. Maximum number of deliveries for maternity leave or yung number of yung pag-avail ng maternity leave, sir?
Maximum, I think it's still 4, no? Kasi for yung threshold natin, no, even sa lahat ng benefits sa paternity leave and also sa sa BIR, yung deductions for dependents for siya. Pero I will I forgot, no, hindi ko masyado matandaan. Pero
we'll check. Nandito ito sa dun sa pinoward natin na labor manual sa inyo. Next, if an employee works on Saturday and it is the employee's rest day, ang tumama special non-working holiday and nag-work pa siya between 10 to 6 a.m. Will the employee still subject for OT and other additional compensation? Medyo
yes, lahat 'yon, nagko-compute 'yon, no. Step by step siya, no. Ko-compute mo muna yung holiday pay, saka yung rest day pay niya, pati overtime pay niya, saka yung net differential niya, no. May computation, may ano siya.
Ang next natin, sir, may specific law daw po ba sa pag-claim ng paternity benefit or leaves sa mga kapatid nating Muslim na tatay?
Yes, no, especially for our Muslim brothers, no. Since under their law, no, they can have 4 spouses that are legal, no. Legal siya, no. This paternity law does not distinguish, no, religion. And basically I have not handled yet, no, yung any complaint, no, sa ganung situation, but I'm not sure if the Sharia law will apply also, since the Sharia courts will also be different, no, from our regular courts, no. Kasi if you are part of our Muslim community, no, you have your Sharia law and your Sharia courts, no, may mga Sharia lawyers din. Okay, so maybe you can consult a Sharia lawyer, no, kasi specialized din siya, no. But to me, no, since equal protection of the law, no, it should also apply, no, to our Muslim brothers, no. They should have we should not discriminate.
Another question last po ay kung do we have a law particular sa mga award, mga nag-award na employees, will they still be able to get it right with their organization?
Wala, pagka absent without leave and you were the employer adheres to the 2 notice rule and you were dismissed or terminated from employment based on that, no, so it's a legal ground for termination, so it will be part of your 201 file already, no. So if you would be getting a certificate of employment, it can be indicated there that you did not resign from work. Okay, your termination from work was not voluntary, but you were dismissed, no, because you were absent without leave, no, from work. So it can be indicated in your certificate of employment because it will be part of your 201 file.
Ano pong gagawin kung ma-terminate dahil hindi nagpa-vaccine?
You can always file a case, no. So you can file a case. Alam niyo yung SENA, yung single entry approach, no. Request for assistance to arbitrate. So you can file that in DOLE. It's already online. You can file an online complaint, no, request for assistance. Then automatic there would be a mediation na as in kay mediator. So it will be already a complaint for illegal dismissal na siya.
Ayun. So 3 months na daw sir hindi nabibigay ang back pay. Tama po ba 'yon o anong gagawin niya? Well, siguro mag-file ng complaint din with Dole.
Yes, you
Apo.
still part of the company, Dole. Pagka na-terminate ka na, depende sa amount kay NLRC.
Apo. Considered po ba na overtime yung ginawa ng employee? Kunwari po nagtatapos siya ng report, tapos lumagpas na po siya ng 8 working hours while finishing the report.
Usually there is a break first, no? A 30-minute break before the rendering of your overtime work, no? And the overtime work should be agreed upon by both the subordinate and the superior. Okay, yun ang importante, no?
Yeah. So kasi yung overtime, may ano yan eh. Usually may form, may slip na pinipirmahan na mag-overtime ka, tas allowed ka. Pipirmahan yun yung security mo na in-acknowledge ng HR or ng admin na ikaw ay mag-overtime. May karapatan po bang mag-demand for OT ang isang employee if nag-work siya for more than her scheduled time, tas papasok or tatama na po 10 p.m. to 6 a.m. Sobrang overtime yun unless nagsimula ng late ng gabi. Base po kasi sa rules of ng account, walang OT daw po pag walang dagdag request ng work and kahit umabot na po ng tanghali, di bayad ng OT.
Then you can refuse to work, no, after the working hours. So you can definitely refuse to work. Di ba may bandy clock naman kayo? So after your work hours, after the 8-hour regular work hours, then if you are not given that authority to work overtime, then you can refuse to render service already to the company. Hindi na siya insubordination kasi ano na siya eh. Above na siya ng work hours mo.
Yun yung last question na siguro natin. Sa question kanina, I think i-review niyo yung expanded maternity leave. I think regardless of, ang update is yung regardless ng gaano kadaming beses ka manganak na may update mo siya from the previous nga na yung existing na in that natin na 4. So
4 akala ko 4. So only na ngayon, only baby sa tayo ngayon.
Only na. So ayun, thank you Attorney Miguel. If meron pa ba tayong tanong, yung notes natin for this session, we will prepare the notes, we'll send it to the department, to your HR department, and then they'll be the one to send to your coordinators and to all the students. Nag-send na rin pala si Sir Francis yung lecture natin kahapon ng we'll be sending it again to Sir June para ma-receive ninyo and we'll be giving you an additional reading materials. Yung notes ni Attorney ay yung lecture ni Attorney ngayon, very vital yun kasi lahat ito kasama to doon sa mga topics na covered topics natin doon sa CHRA. Mag-iiba lang siguro yung mga situation, parang cases ganyan, but the concept, so very important na yung diniscuss niya ay natandaan natin. But we'll give you a note, parang notes or summary or reviewer for this one. Again, thank you, sir. Jeric, please. Ayun. So again, nagpapasalamat tayo kay Attorney Miguel. Laging isang isang tawag, isang text. Last time, nag-lecture naman siya sa Negros Oriental State University. Sir, on behalf of Rizal Technological University and the Human Resource Educators Association of the Philippines, we are giving the certificate appreciation to Attorney John Evan C. Miguel for sharing his knowledge and insights as lecturer reviewer in the Certified Human Resource Associate Review Session, given this 30th day of June, signed by yours truly and Professor Perry David Alsolosa, the President of HREAP. Sir, again, maraming salamat at yung inputs nyo sobrang malaking matutulong doon sa mga bata and ma-inspire din sila na to really siguro dig deeper pa doon sa mga labor laws para pag naging HR practitioner sila, gamay na nila. Kasi very essential yung labor laws yung HR related laws, talagang nandun din yung buhay ng HR. Yung mga recently, sir, yung what happened to a certain, off the record, to a certain company in Valenzuela about legal tender. 'Di ba? Just now, just this afternoon, sinuspend na yung business permit. Imagine, a simple action by an employee or with or without siguro consent from the top management can actually affect the entire business. So malaki yung role na ginagampanan ng mga HR practitioners, mga HR natin. So pag naging na-employed kayo sa HR, talagang very critical yung trabaho na gagampanan niyo. Ayun. Sir, maraming salamat po. Thank you po for your time.
Thank you, Prof. Joseph. Thank you,
Salamat.
everyone. Thank you.
Bye-bye, sir.
Thank you.